May be seated. Before all the parties are present, before we bring the jury in, it's my understanding that the defense is going to rest at this point?
Yes, Your Honor.
All right. What I would do is bring the jury in, have the defense rest. I also understand that the state's not ready with rebuttal witnesses yet today.
True.
Yeah. May I ask how many witnesses you anticipate?
Judge, I do think we should have a discussion about them because Attorney Zachar may have some objections. So the first one would be Dr. Enriquez. I don't want her to talk about both children. I don't want her to talk about the other acts. I'm not looking for her to talk about the scope of the report. I would be asking Dr. Enriquez to testify very limited to the expectations of what symptoms Alex Xavier would have exhibited based on her training, her experience relative to being a child abuse pediatrician.
Symptoms from the abuse aspect or the Xanax exposure?
Symptoms related to the physical abuse.
The physical abuse. And as I said, I believe she could be called as a rebuttal witness if there was a need. Was it contradicting what one of the doctor that Dr. Christensen said?
I don't think it's contradictory. I think she provides greater detail and greater information because she deals with live patients who have had these injuries, so she can talk from that perspective what one would expect in these scenarios. I don't know that either Dr. Christensen or Dr. Quinton had that ability. And so that would be the reason that we'd be calling her.
Okay. And then just before we get into an argument about whether that is appropriate or not, is there another witness other than that?
There is another witness. We made arrangements last week. There were a number of physical pieces of evidence, the pair of pants that Alex Xavier had with pajamas with a blue substance on it, and then the little fragments that were collected by the department. It was our belief always that those were sugar, that they were not pill fragments. During the course of the trial, they were referred to as pill fragments. We did not send them to the Wisconsin State Crime Lab. We actually had them tested at the University of La Crosse strictly for sugar, and they came back as sucrose, sugar, which is the predominant ingredient in cotton candy.
All right. Is that something you two could maybe talk about? We could just...
Well, Judge, I'm going to have objections.
Okay. All right. Okay. So that's fine. I'm just trying to get an idea on timing-wise. So this is what I'm going to tell the jury is that, first of all, the defense is rested, that we need to wait tomorrow for some potential rebuttal witnesses. Probably my hope is that we would be able to do jury instructions tomorrow, maybe even closings tomorrow, and at least give them the opportunity to be able to deliberate all day on Friday. I know I'm always pushing it maybe a little bit too fast, but we'll see where we're at the end of tomorrow morning. Either way, closings would be at latest Friday morning. That's what I can see is doing like jury instructions, finishing them, because jury instructions are going to take a while, just simply from what I understand. So let's bring the jury in right now, and we'll give them the break and go from there. Now everybody may be seated. Mr. Zachar, does the defense rest at this point in time?
Yes, Your Honor.
So, ladies and gentlemen, the defense has rested, which means we go to the next phase, which is the state has an opportunity for something called rebuttal. Because it's a little bit, timing was a little bit off. What we're going to do is start that tomorrow morning. So we're going to be done with today. My hope that, knock on wood, my hope is this means that we should be done this week. Of course, there's no, as deliberations, as you've heard me say this before, I cannot tell you how long that takes. That's really up to a jury. But at least as far as the finishing of the full trial going to the jury, my hope is you'll have it no later than Friday at the latest. Good news. The other thing is, if you can come back tomorrow morning, 8:30, we should start right up with whatever witnesses, if there are any witnesses, and then we'll go to the end of the trial. Thank you so much. Please don't talk about the case as usual. We'll see you tomorrow. Everybody may be seated. Just let you know, Christina is taking what was sent to by the state to and is now we're incorporating it. Of course, we can discuss it. That's just to have so we can talk about the entire thing at that point in time. Sort of what I usually do is I make copies of the instructions, give you both copies of it. I'll have her send you an electronic version of it too, and then we can start working through it. Probably not till about 3:30 is when I think we'll be ready. She's working on it as we speak. One other question. This is a really Mr. Colkine's not being called as a rebuttal witness, right?
We don't intend on calling Mr.
Okay.
Colkine.
There's a logistic issue which we just need to clarify. My also hope is that we'll be out of here in a decent time today and then tomorrow, of course, but regular time. Anything else we need to talk about while we're waiting for that to be done?
Judge, I would like to argue the objections on the proposed rebuttal witnesses.
Okay, why don't we do that right now? Go ahead.
So, Judge, as the court recalls, Dr. Iniguez was excluded on a couple of grounds, both relevance and as well as in the context of the Daubert hearing, as well as the discovery violation. What we're looking at here is whether or not this is bona fide rebuttal, as defined by State versus Cacciatolo and subsequent cases. Bona fide rebuttal is not any evidence that the state wanted to put in this case in chief. It's not evidence that's defined by context or providing additional information. It's in direct rebuttal or response to our case. We were very careful not to open that door to Dr. Iniguez testifying on rebuttal to these issues. Both Dr. Christensen and Dr. Quentin testified that this would be expected to be a painful injury. We didn't contest that testimony. They testified to that. I agree the court or the state can argue that, but there is no disagreement that Dr. Iniguez is coming in to rebut. Rather, the testimony that's coming in rebuttal is testimony that the court excluded in the state's case in chief, and they're just trying to backdoor this as rebuttal evidence. It's not in response to anything that we've raised, and particularly if it's just being offered for context or information as to how a child might react in that situation. That's evidence that a reasonable prosecutor should include in their case in chief in direct and was excluded by the court as a result of the discovery issue. As to the lab evidence, this was evidence once more that a reasonable prosecutor should have tested and produced before trial. They had 3 years to send this to the state crime lab, and they didn't. We also intentionally avoided opening this door. Attorney Torbensen emailed me, I believe, last weekend saying that they had this tested and the presence of sucrose was detected, and advised me before I cross-examined Sergeant Amundson as to that. In the process of this, I asked Sergeant Amundson a very specific question. Before trial, were any of these substances tested? And he said no. I did not ask subsequently. The state did not redirect with subsequently. We intentionally did not impeach Sergeant Amundson with comments on the body camera where they're describing on the body camera, looks like it could be a pill fragment. When collecting this evidence for that reason, I didn't want to open up that door. Additionally, I think this is problematic in that we requested a copy of the report or any other documents immediately after we were notified of this, because what the state's describing is effectively exculpatory evidence, where this is also inconsistent with the state's theory of staging the scene to make it appear like an accidental overdose. We've received no reports at this point. Obviously, I don't have a multi-million-dollar crime laboratory on retainer to get this evidence retested in the meantime, but this is not within the scope of rebuttal to say that we didn't test this throughout the case, now we're going to do it mid-trial and introduce scientific testimony, which has yet to be disclosed to us, contesting, consistent with the state's theory of the case. It's evidence that should have been tested. It's evidence that should have been tested a long time ago. It's also problematic in that, as the court knows, my wife works at UWL. I know a number of these people. I don't know who they're going to produce, but these are certainly people that I've met and have interacted with in the past. But just looking at this, I think, one, it's a violation of the state's obligation to continue to disclose exculpatory evidence as it came in. It's arguably exculpatory. Two, I don't think that this is bona fide rebuttal evidence as defined by Cacciatolo in direct response to something that we did here. The issue was, were they ever tested before trial? They were not. The state can't come in then and produce scientific evidence that we have absolutely no opportunity to rebut. We have no opportunity to assess the validity of this. If it's a student assisting with testing, if it's a test that's specific to sucrose or specific to or includes testing for controlled substances in addition to that, it's too little too late. I think that this is unfair surprise and that this evidence should be excluded in its entirety.
Let's talk about the lab testing first. Why don't we do that first? Go ahead.
All right, State versus Hatcher is the case that says that an issue that is raised during cross-examination by defense counsel can lead to rebuttal evidence on the part of the state. It's always been our theory that this is sugar. We said it from the start. We've talked about this being the cotton candy that was all over the floor, on the pajamas, and in the bed. That was the testimony essentially of Investigative Sergeant Rich Amundson when he took the stand. The first I've heard of a pill fragment, and pill fragment was used throughout the questioning of multiple of the on-scene initial responding officers by defense counsel. They also used pill fragment when they were questioning Lieutenant Williams, when Lieutenant Williams was on the stand and not having the pill fragment tested. That raised a bona fide question. One of the things that State versus Hatcher talks about is that a jury trial is a truth-seeking function. The truth-seeking function here is having the testing completed and demonstrating that it is what we always purported it to be, and that is sugar. So the substance was tested. As soon as this issue was raised, we made arrangements, not with the Wisconsin State Crime Lab because they test for drugs. This is not drug testing. This is testing to verify that it was in fact sugar, which is what we believed and not what the defense was suggesting it was during trial. The testing came back as sucrose at a higher than 98% rate. It's been compared to other sugars, including other sugars that are often used in pills to constitute Xanax pills. It's lactose that's actually used in those pills, and it doesn't come back consistent with lactose at all.
So the people who tested this, did they know that?
They knew that sucrose was the main ingredient in.
But they're not experts in pills.
They're not experts in pills, and I don't anticipate them testifying about contents of pills. But I'm providing that information to the court to know how careful we were being in having this testing conducted. The student that tested, it's actually not a student. It's a doctor. His name is Alex Paulson. He just transferred to the university from Michigan last year. So he's been with the University of La Crosse for 1 year.
Judge, could I respond on the legal issue?
Go ahead.
Hatcher, as I understand it, is an unpublished but persuasive opinion. The opinion that I would direct the court to was State v. Konkol, Konkol. That was a case that addressed bona fide rebuttal with fingerprint evidence, where in that case the state was surprised by the defense indicating that he only had one beer with a .12 BAC, and they were permitted to introduce fingerprint evidence on other beer bottles or beer cans, I believe, to rebut that defense. The issue there was legitimate surprise. This should not have been a surprise. We viewed these pills, they were collected, or we viewed the substance, it was collected. It's something that's been on the radar for a long time in this case. And additionally, professors' findings here in the testing on this substance, we're entitled to a Daubert hearing on that. If they're going to discuss the veracity of these tests or the range of substances that were tested for. And I mean, that would be my request, is that we have a Daubert hearing on this matter as well if this introduce this.
But you don't have the report, right?
I do have the report. I can have it sent right now. I think it was just the final report was provided to.
But as we speak, he does not have the report. The state doesn't. The defense does not have the report, right?
We just got it.
Yeah. All right. Two things. One, I don't think this is a surprise. I think this material was all over the place. It was there. It could have been tested by the state a long time ago. It's been around 3 years. Actually, there's been a lot of evidence here that there's cotton candy, et cetera. It was brought to the attention that this did not look like it was a pill, et cetera. It wasn't tested by anybody. So having this type of testing is not, well, first of all, it was not a surprise because it was always around. It was in the scene. It was collected by the police. You know, if there was a statement by, it was an officer who said it was a pill fragment, I believe in the video.
Well, it was Deputy Jar talking to Sergeant Amundson on the body camera, where they said something to the effect of, sure looks like it could be a pill fragment, could be candy, we don't know.
Right.
Yeah.
So at that point, that was evidence that comes from day one, moment one in the case. If the question was raised, and this is not a surprise to the state at all. I agree that there would be a whole process of having, you might have the report right now, but they would also have a right to test it too, if they wanted to test it. So I'm not going to allow that lab evidence to come in. That's going to be excluded. Now, why don't you argue the other issues of the Dr. Nunez? I apologize if I'm mispronouncing your last name, but go ahead on the issue of the doctor.
Me or?
Yeah, yeah. I think they already made their argument that they believe this was. They made the argument earlier. Actually, and I do have a question because this goes back to an original discussion we had just before we took the break. You said her testimony would be really more of an elaboration of what a child would feel.
She can provide more details regarding the symptoms of the child and the time frame for those symptoms because she deals with live patients and not individuals who are dead and performing autopsies. So she brings that unique experience. And in the testimony of Ms. Dikeman specifically talked about not really seeing any symptoms or not really seeing any symptomology. And I think in particular in this case, the symptoms that Alex Xavier would have had and the timing of those symptoms is actually a big issue.
And especially if the theory that if the theory of the defense is that this just happened only moments before he was arrested or within an hour or two of being arrested, So she's rebutting essentially what's being asserted by Ms. Dikeman, is what you're saying?
By Ms. Dikeman, that these injuries were inflicted during the narrow time frame that Mr. Pedram was there. Yes.
Or the observations of the pain, in other words. It's really rebuttal of the observations of the pain. Is that correct?
Yes.
Okay. All right. I'll give you an opportunity to respond to that.
Judge, it was something that was both raised with both pathologists who testified as to the pain that could be expected. We knew that to be testimony in rebuttal to Ms. Dikeman's preferred testimony. It was effectively done. This is something that the state noticed with Dr. Iniguez in the expert testimony that was excluded on direct. That does not make this bona fide rebuttal to say that we want more context or more information. The jury's already heard that testimony. And this, again, is surprise. We're going to bring in it's something that was well known to the state that this would be an issue in advance. It was something that was contained in the various expert notices. I don't believe that we opened that door at all. In fact, we didn't object to the questions about pain level that a child could experience under those circumstances. This is more of the same of what the court excluded. It's not scientifically reliable. Dr. Iniguez's experiences, however many or however few that she has, are not relevant to assessing how Alex Xavier would have reacted. But we've got two forensic pathologists that have already testified that yes, they would expect this to be a painful injury, and yes, they would expect the child to be exhibiting symptoms. It's not in response to anything that we have presented in the course of our case, and therefore it's not bona fide rebuttal.
Yeah. So first of all, on the qualifications of Dr. Iniguez, she's a specialist in the area of unintentional injury of children, specifically, or intentional injury of children, specifically when there's multiple planes of injuries, the severity of the injuries. She testified to that. She has the background in that area. She also testified to her qualifications and the research that she did. I did say at the time that I could see that she meets those qualifications to allow her to testify. The real issue that came down to, which excluded the testimony in chief, was the issue that the court felt that it was basically the report was not turned over until we actually had the Daubert hearing, which was too little too late. What the court will say is that I believe she can testify to a very limited purpose, which the state has outlined. Talk about these type of injuries would cause this type of pain in those she has worked with, and what she knows from whatever research she knows. But it's only about that issue. She's not to talk about it's her conclusion that this is a intentional infliction of injuries. What she can talk about is these type of injuries cause this type of pain, and when you would feel it, basically, because you would feel it soon after. I'm assuming the testimony will be soon after it's inflicted. Is that clear enough?
Pain and symptoms is the way I understand.
Pain and symptoms, yeah. Pain and symptoms. So she's allowed to testify to only that limited purpose.
Judge, I'd still like to Daubert Dr. Iniguez on her experience and rationale for her testimony in that matter.
We had a Daubert hearing. She seemed to have testified about her experience with injury. Are you talking about where the pain is?
Where the pain is, what experience she has with patients with this particular injury, how she can make that description, whether or not she can generalize that description to all children. All
right. What I'll do is we'll do a small, on that specific issue, we'll do a small hearing on that. I'd actually sort of like to hear what her testimony is so I can understand exactly how this will come in. But not only that, I think with her experience in this specific area, meaning the injury and its effects, without having going back to it, I'd allow a little bit of voir dire about that issue beforehand. So we'll be very specific area. I'm still at this point inclined to allow her in, knowing what I do know what she knows, unless there's something that comes to our attention in this process. But what we'll do is that if you can have her at 8:30, is that possible?
Flying in from Cleveland, so I don't think she'll be here until late morning. We're working on maybe getting an earlier flight. I'm not sure if it's possible, but we're trying. We didn't anticipate the defense resting today, Your Honor.
Yeah, I forgot she was in Cleveland. For some reason, I thought, yeah.
We're trying to get her in earlier, Judge. All the wheels are working downstairs to see if that's a possibility.
Okay.
If you want to come back for jury instructions, we can have an update.
Yeah, why don't we find out when she can be here, but I'll allow there to be a Dauber hearing either way.
Judge, yeah, I'll just put on the record that I don't believe this is in any way, shape, or form bona fide rebuttal. We're being sandbagged with an expert that we are not able to provide a rebuttal to.
I would just note that this topic was actually addressed in the Daubert hearing. I did bring up, because I think the defense was actually, they said that my notice didn't contain symptomology, but she talked about her history with working in a trauma section of a hospital for a number of years and working directly with patients, including patients with these injuries. We had a 2-day Daubert hearing, 2.5 days, I recall, and this topic was well-versed and well-covered during those hearings.
Yeah, I remember this topic being talked about. I'm not sure why this defense believes it wasn't talked about, but let's, but I'll still allow there, because this is a really particular area, I still allow there to be a voir dire. I do not expect to spend more than a few minutes on this issue. I'm not going to spend like 2 hours on this, 3 hours on this issue. So be efficient, in other words. All right, find out when she can come. I'm going to talk to, when do we have you guys come back? Let me just find out what Christina is saying about being ready.
Judge, may I ask a question related to closings?
Sure.
Are you imposing time limits on the parties?
I probably, well, it depends a little bit when it happens, but yes, there's going to be some type of time limits, but it has to be reasonable. I mean, I'm not going to make it 30 minutes or something like that.
I wasn't expecting that. But
yeah. I mean, I think you have to give me, looking at the openings, quite honestly, the States was very short. It was 30 minutes or something like that. Maybe 45. I can go back and look.
I think it was 54 minutes, and Attorney Zachar was an hour and 16. So they're relatively close.
They're relatively short. So yeah, you might be right about that. So yeah, I mean, what are you thinking it will take the state to present closing?
I was just looking from guidance from the court on what the court was going to.
If I gave you both an hour?
It's going to be longer than an hour.
It's not going to be longer, much longer than an hour. I'll do an hour and a half. You'll lose a jury eventually. I mean, we've already been doing this for 2.5 weeks, so so make it an hour and a half. You both have, it'd be total hour and a half.
Broken up.
Yep.
Got it.
Thank you. All right. All right. This might take a little bit longer. Let's say another. Come back in about 20 minutes. Or about 10 to.
Oh, Judge, we would move to release Rebecca Ehlers from our subpoena, and my understanding is that the state is also doing the same.
Yes, we agree with that, and there's a number of other individuals that have been out in the hall that are asking if they can be released. If they are not on the defense list and we're not calling them, can all those individuals be released as well?
So long as the state is not calling them.
Okay.
Yep. Everybody is released who's not being called.
Yeah, and Attorney Zachar, did you want to make a record about the evidence in the bag?
Oh, yeah, so just so we're tracking the forensic evidence here, my understanding is that the chap's bag with the pill bottles was placed back into the original evidence bag, and the clerk intends to put that into a larger paper bag. We're fine with that as long as the integrity of that bag is maintained.
All right, thank you.
Judge?
Back on the record, this is the time for the jury instructions conference, but before we do that, let's talk about, I guess there's some things we need to have received into the record. Also explain what we're doing tomorrow morning on the record. I'll just explain. It's my understanding the state's informed me that the state is not going to be calling any rebuttal witnesses. Is that correct?
We will be calling rebuttal witnesses. We are not calling back our agents.
Oh, you are calling rebuttal witnesses. Oh, I misunderstood that. We can still start at 8:30 tomorrow morning.
Yes, the witnesses that we are calling should be available.
Okay. Can I ask how many witnesses you think? Right.
I think it might be two.
Two.
And I think they'll both be relatively brief.
Okay. And that's fine. That still doesn't change. We'll still need the jury here at 8:30. So once we are done with those rebuttal witnesses, then we'll go almost directly into jury instruction unless there's some variances we need to talk about between now and tomorrow. We'll take a break probably anyway. My hope is that we can get to jury instructions, maybe even closings tomorrow. Does that seem possible from the state's perspective?
I think so.
Okay, defense?
Can I ask who the rebuttal witnesses are?
Not sure yet. We know one will likely be Sergeant Amundson. All rebuttal witnesses we think will be very brief.
I mean, like, yeah, if we could start right away at 8:30 and the rebuttal witnesses are short, which I am hoping for myself, then I would think that we can probably get through closings tomorrow.
Okay. So, yeah, might be, well, we'll see what the timing is. So let's try to get through these instructions best we can tonight. We might have another opportunity before we finalize them tomorrow. Plus, I don't have the verdicts. I know Christina's working on that a little bit. Oh, before we do that, I'm sorry. Let's do the exhibits that need to be received.
The state would move exhibits 147, 149, 150, 151, and 152.
Any objection?
I guess subject to any objections I made at the time, I'll let the court make that determination.
Okay. When were those made? Or when did we?
It was probably all this afternoon.
It was when we continued after.
Yeah, I think 147 was a picture that included the, I think the rest of the text messages or.
Yeah, I see. Okay, yeah. So they'll be received. I see what they are. Those are text messages. Picture, of course, is received. Okay, any from the defense? Were there any, you think you got them all?
I think we've got them all. Madam Clerk, am I correct in that assessment? All right. I'll note that we put the 2 digital files that we used today with Ms. Dikeman, the 2 Walmart videos on Defense Exhibit 203 as labeled.
Okay. All right. So let's talk about the instructions and at least get to the parts that we need to be modified. just starting on page 100 is standard instruction, goes to page 2. Any changes on that from the state's perspective, defense?
With the caveat that we are objecting to the lesser included on count 1.
Yeah, I'm just getting through 100 here.
Sure.
Now, we are going to count 1 with the lesser included. Let me ask, the state has submitted, and what's the objection for the lesser included?
That there's not a factual basis for either first degree reckless or second degree reckless under the circumstances that were introduced in this case. The state tried it as an intentional homicide, and we already have the same death charged 3 different ways with counts 1, 2, and 3. I think it's redundant. I think it violates Ms. Dikeman's due process rights and her double jeopardy rights. If the court was inclined to give the instruction, I would also note that I think it's incongruent with the other counts as well, that if it's not an intentional death, then it's a reckless death, then it's a negligent death, then it's child abuse causing death. It can't all be the same thing, so I think it's confusing the jury, and I would ask the court not to give that instruction.
Counsel?
I would argue that actually each one covers, especially counts 1 and counts 2 cover separate and distinct conduct. Count 1, the state's asking for the lessers because this involves a caretaker being accused of committing the homicide of a 6-year-old child in the home, and I think jurors naturally struggle with finding a caretaker and someone who they have a relationship with a child guilty of intentional homicide. I think for that reason, a jury reasonably could come back guilty on the greater charges or the lesser charges given the evidence in this particular case. With regards to count 2, that's different conduct here. There's a number of ways that the state alleges that Ms. Dikeman is neglectful. The neglect leading to the death of the kid in the state's perspective is administering a drug to the child and then not monitoring the child's well-being thereafter to ensure that the child was okay, safe, getting medical care soon thereafter. Certainly that's different conduct that also would contribute to the death of the child. I think with regards to count 3 is repeated acts of physical abuse. And the only question that I'm asking for is that they don't agree as to the act that resulted in the death. That would be a separate question asking if they agree as to the act that resulted in great bodily harm. Again, with the same suggestion or instruction, I should say, not suggestion, instruction, that they must agree on that specific act. The defense has put into contention specifically the injuries that were physically inflicted on the child outside of the drugs, that they may not have been life-threatening per se, and that was the drugs that killed the child. That in and of itself establishes grounds for the jury to consider a lesser included and consider whether or not the broken bone, the rib fracture, the lacerated liver, all different forms of great bodily harm that the jury could certainly come back on with regards to that. I would also note that the physical abuse charges are all charges intentional, but all we have to prove is intentional infliction of bodily harm, which is physical pain or injury or impairment of physical condition. It's very different than the intent that charge in count 1.
Yeah, I first of all, just going sort of backwards, I think count 3 and with the addition in count 3, I agree that could be the result, that an individual could say, well, there was great bodily harm, but there was no death from that great bodily harm. And count 3, if you can prove the 3 acts, you could get to count 3. Count 2, a question I have in count 2, and we're going to edit this a little bit more. Count 2 also has the added language. We put all the language in here. Protection for exposure to the distribution or manufacturing controlled substances. Under section 961.01 parent 4, and controlled substance analog is defined in section 961.01 parent 4M, or to drug abuse is defined. Is the state asking me to put all that language in? And I'm looking on page 11. I think it actually repeats itself twice in the. It's also on page 10. It's the elements under element 1, and then it's also under C,
But I don't think that there's any allegations in this particular case that Ms. Dikeman was manufacturing controlled substances. So
Right.
that can be struck. I don't think there's any allegations from the state's perspective that she was distributing the drugs to another as the form of neglect. I think the allegation is that from the state's perspective, she may have administered it to the child, but I don't know that that's what's meant by distribution. So I think distribution could be struck. I think use of controlled substance analogs can be included, or drug abuse, the language of drug abuse as defined in 46-973, sub 173. So I'd ask that that be included. I don't think there's an allegation as to necessary shelter, so I think that could be struck. I don't think we're making any accusations about the clothing on the children. That could be struck. So I'd ask that education remain in and exposure to drug abuse remain in. And then necessary care and all the other language.
Yeah, necessary care. Well, the question is, then do you have to have the definition of 46.973 parent 1 parent B included in the instruction?
That'd be helpful.
Yeah. So just to make sure, and then I'm going to give you an opportunity to respond, Mr. Zachar. And I'm working backwards because I want to get to one. And the second here is that it would be, I'm looking at page 10. It says, for emotional health of the child, colon, necessary care, comma, necessary food, comma, necessary medical care, comma, education and compliance with section 118.15, and then or, and then it would jump all the way, or drug abuse as defined under 46.973 parent 1 parent B. Is that was what you were saying? Okay. Counsel?
We're just looking to see whether or not that language was used in the amended information. I can't recall.
I
may have just used necessary care. I can file amended information to reflect. I think this is what, that would comport to the testimony that was given at trial.
If it was necessary care, my request would be necessary care. Like I agree, the state can argue that protection from controlled substance constitutes necessary care, but I don't know that we need it, especially if it wasn't in the amendment.
I'll be frank, the problem with having the added language is that you start having other definitions and gets confusing to people. But I think you need to have them. So if compliance in section there's evidence there. I was going to say, does the state really feel that the education in compliance with section 118.15 necessary? Because I think that's the requirements of showing, I'd have to look it up, 118.15 if I remember right, it's about attendance.
It is about attendance.
Yeah. All right. Well, right. I'm going to leave this in. I think that's appropriate. State can modify, but I'm going to have education in compliance with 118.15 or, and then drop all the way down to or drug abuse is defined in 46.973.1, 973 parent 1, parent B, and that would be repeated on the next page. Now, going back to the question of the lesser includeds, I mean, I think that in this case, reckless homicide, both 1 and 2, assuming the facts, if the facts are believed by the jury that the defendant was involved with the behavior, the intentional infliction of injury, the real question was the intent at that point, or was this just reckless behavior? And I think it's easy to say it could be reckless behavior because of sort of the because of the behavior of the defendant during that's even described. If making a bunch of assumptions here that the defendant's not believed at all, and that they believe that she's really the source of the behavior. The question is, was the behavior reckless in the acts that she did? Hold on one moment, I'll be right with you. So what I'm going to say is this, is that I think the lesser includes are I don't think they are redundant. I think they're not these acts we talked about in count 2 or the acts in count 3. It's really the behavior which either 1 was intentional, 2 with reckless. The next question was, is reckless with utter disregard or just reckless without utter disregard? Obviously, a jury could look at this and say, well, yes, this was really criminal reckless behavior, but she didn't form that it wasn't utter disregard as far as behavior. It was at a level that caused this result of death, but was not utter disregard. So I think that's logically a lesser included that could be included. And I don't think it's redundant to especially count 3, which I'm looking at, because the physical abuse of a child is saying you do all these repetitive acts and then you cause the death, and that's what eventually led to the death of the individual child, where the count 1 is more about the particular behavior of that singular, even though there's multiple events in that singular event, there's multiple, it's more of a focus on that night. And I think that's why it's not necessarily duplicitous in its nature. I also think that the case law is says you should be able to do that. That's how you should look at it. It's not like a blockbuster. Did I say that right?
Blockburger.
Blockburger. I knew I had the wrong word. Thank you. Example. Now, having said that, yes, I'm going to allow the lesser included. The next question is what's going to be here. We've talked about count 2, but do you have any problem with how 115 is constructed then, Mr. Zachar?
So, Judge, the court might recall in a prior trial we had an issue where I had submitted a proposed instruction with additional language on what substantial and reasonable means. And yeah, lo and behold, that was the only question the jury had is, could you define that for us? I'm going to see if I can dig that language out and see if it's appropriate in this case.
Okay. Well, for 115 for right now, and I know we're going to spend, we don't have to be here all night to try to figure this out. I want to give you guys some time to look this over, but for right now, 115 will remain as is. What I will do then is...
But just so I get this on the record, for the count 2, our objection to including the additional language not in the information is on notice, and that this was not charged in the amended information. Ms. Dikeman was not given notice that she was to defend beyond the standard of care that was limited in the amended information, and the state hasn't made a motion to amend consistent with the evidence at this point.
Well, actually, sort of said that you were going to.
I'm going to file amended information. I think the criminal complaint has made clear, and the witnesses were on notice for a number of years now what the allegations were in this specific case. So I'll file an amended information tonight that conforms to the evidence.
Okay.
The language that we're seeking on count 2.
Okay, so, and then in count 2, the only additional issue is, and I'll amend this once we're done here, is adding that extra language for those 2 definitions, which I would probably put in probably right before, I think I'd have to put it before D. That's a paragraph. Yeah, that would be in paragraph, page 11. There's a paragraph C, and it would make sense to put the definitions of 118, 15, and 46,973, parent 1, parent B, right there. Did the state agree? So that would be a good place for that? Defense?
Yes.
And then you would go on to D and E, and then count then to 2, which is an element, the greater elements. I'm never sure how to talk about these elements. They're elements within elements. And then in 3, which is, as we already talked about. Any problem with that modification? I'll do that and get that to you. I need to work on that language then. Mr. Zachar?
I always prefer simpler language if possible, rather than say 3 violations of section 948.21. We could say something like at least 3 violations of neglect is defined in paragraph 1. I understand it's a form instruction, Judge, but if we can simplify it, that would be my preference.
Any objection to that?
No, at least 3 violations of neglect as previously defined involving the same child.
Yeah, that works.
As previous defined. Okay, yeah, so I'll get that. And then going back to involving the same child took place. Okay. All right. Then count 3, I always love it when there's multiple statutes in these definitions. You have to in this case because it's repeated acts, but
We can strike, I'm only alleging 948.03 sub 2, I believe, in the instruction. So if you want to strike in that first paragraph on page 13.
okay.
Section 948.03 or section 948.03 sub 4.
Okay.
You can strike that language.
So it would just be in violation of section 948.03, parent 2. And then I'd strike those other sections of the Wisconsin statute, at least one violation caused the death of the child, contrary to 948 point, and that's just the statutory language. I don't think we need the do you need the 939 language in there? Is that that's the, is that the actual sentencing statute?
Yeah, it's the classification of
Yeah,
felonies.
it's the classification of the type of felony it is. So I usually take out the classification of the felony in it because that's not for consideration, really.
No objection.
Okay. Is that true in count 1 too? Sorry.
Yeah.
Yeah, I think it might be in count 1 too.
Yeah, it's there.
No objection to removing those uniformly.
All right, yeah, so I'll take out the 939 references. I noticed that actually when I did the original.
That count 2 too.
2, yep. Okay. Okay, so that's count 3, page 13, and get to page 14. Any problem with page 14? No. You wrote it. Should be no.
Yeah, I'm just reading on to 15. No objection.
Okay. Yeah, and then page 15. Any problem with 15? 15 to 16. Go all the way to 140. Oh, this is the question I had about the language. I just had Christina send me the email you sent. I think we have it wrong there.
There's no second question about grave bodily harm.
Yeah. So it's the section that says if you cannot agree on the violation that caused the death, you should consider the following question. That section, right? Okay, I'm gonna. I just want to try to get this in right now before. So that will be stuck in before 140 in the jury. So on page 16, before 140, I'm adding that language which the state had submitted, but we did not include. Is there any? We'll get you a copy of it so you can see what it looks like. But it's exactly, I just cut and pasted, exactly the same language, just so you know.
Obviously, same objection on the lesser included as the court's already addressed.
Okay, thank you. All right, then going on to sort of some standard instructions. Get to 140, it's burden of proof. And then 140.
But I think the reasonable hypothesis language is outdated. It still says should instead of must.
I'm glad you caught that. I may have said should, and when we did the original instructions, just so you said no. We changed that. I don't understand. See, we're pulling this off the court website. For some reason, that's still coming up should.
Yeah, I know 140 was changed quite a few years ago. But
yeah, I don't understand why that's happening. Anyway, does the state have any objection to that? Okay. Thank you for catching that. So that gets us to essentially to 145, which is on page 18.
Standard instruction, no objection.
Yeah, standard. Any objection? The next one we have 103, standard instruction. Any problem with that?
No, Your Honor.
There was the stipulation that was read to the jury, which is agreed upon fact. How does the court handle that?
Well, I think wasn't there there's a stipulation. Oh, no, it says it right there. That's right. To be honest, I have not, because the stipulations I've had in the past have been ones that were stipulated in the trial, and so people heard them. I did not send them back to anybody. I did not repeat them. I think they've been referred to. Is there a feeling like because there have been actually more than just that one stipulation. There's some other bits and pieces been stipulated too. What were you thinking?
I just wanted to make sure, I'm not suggesting that it be inserted and then be read again. I think my question was more so how is it being handled if the jury has to see the stipulation again? Would that be brought in court and it would be read to them again? And that's something we can address later, I guess.
Yeah, and that's exactly, I would bring them into court. It would, if we think it's appropriate, we'd read it. I don't know. I'm not making that determination, but if it was going to be done in any way, it would be done that way. It would be in court on the record then. You're right. We'd probably do the cautionary instruction again too. And I can stumble through it a second time then. So another option. So having said that, but not even a little bit of a laugh. Anyway, it's been long days, guys. Okay, 170.
Standard instruction, no objection.
I'm going to get rid of the paragraph about escape, flight, concealment.
I don't think 270 applies.
I don't think 270 necessarily applies, but I don't know. What's the state think? $270 is yeah, I don't believe there was any specific character evidence about the defendant. So, well, we move 270. Remember, we throw in the kitchen sink a lot of times here, just to make sure.
No objection to 155.
Objection.
Yeah, that's standard. 155. 275. Actually, what I'm going to do in 275 is, I think that's just the standard 275. I was going to use the instruction we had used. There's a different question, but the instruction we used during the actual trial, which I believe I gave you copies of, correct? Okay.
No objection to swapping that language.
Okay, hold on one moment. Okay, so that will have that different language.
Would this be an area where we incorporate the 275 for both?
Well, that was my next question, is that I would start with the cautionary instruction of other acts for the defendant, and then there would be an instruction for what you're asking is an instruction for Mr. Pedron also.
Correct, yeah.
My issue with that, Your Honor, is that Ms. Dikeman's entitled to the constitutional presumption of innocence. Not, and those other acts were stipulated.
I agree with that, but they have to come in for an evidentiary purpose, and only for that evidentiary purpose, and that's exactly why we have 275, because it tells them what evidentiary purpose it is, and it specifically tells them they can't use propensity, and they cannot argue propensity in closings. So the law is the same for both. I would just ask that the same instruction be used for both the permissible purposes that they're suggesting that. I'd actually ask for the propensity-free reasoning instruction that Mr. Bowles added to the instruction, if that's going to be used for the other acts of Ms. Dikeman that the state has offered. I'd ask that the very same instruction be given regarding the other acts of Mr. Pedron.
The purpose that, so it's also identity, I believe.
Well, I think we pleaded motive, opportunity, identity, intent, context, credibility.
All right. This is what I would suggest is maybe work on whatever instruction you think should be for 275. And I can't do that right now for Mr. Pedron. Let me look at it. You know, I think for what I would end up doing, just so I'm just taking like a look at this, is I probably, if I use it, would stick it in before the propensity-free reasoning requirement, because there's, the identity was only used for Ms. Dikeman, so now we have the other reasons for Mr. Pedron, which might get actually more complicated to write. Plus, it was a few more incidents. I don't know who wants to write this. I know it's not your request, but
I can submit a short list of the statutory purposes that we submitted Mr. Pedron's evidence for, if the court would, if that would, we can plug those in.
If he gives those, sends those to me, I can grab something and submit.
all right, why don't you two talk before we leave? Okay. Just want to put a little. Okay, so assuming we work that out, then we get to 157, which is standard. 148. I do not have improper questions. We probably, oh no, we do have. We have 147 and we have 150. So those are all connected. Any objection to those? No. 158 is the
I would just ask that the court adjust it to past tense of you heard an audio recording, you heard audio recordings and viewed audio-visual recordings, recordings of proper evidence, et cetera.
yeah, I would just put you heard and viewed audio-visual recordings. But it's sort of a 158 is interesting. It seems to say, hey, you're about to do this. What if I get rid of that last sentence? Listen carefully. Some parts may be hard to hear.
Fine, Judge.
And but you can also, you may consider actions, facial expressions, etc. We are not going to be. I don't believe we provided a transcript for any of them.
No, and the transcriptions that we provided were solely to comply with the local court rule on DAR reporting.
So I'll get rid of that last paragraph. Mr. Torbensen, you agree? Okay, then we'll get to 190, that's standard. 195, standard. 200, obviously, do you want to have the paragraph about the defendant testifying?
What is that, 205?
We are at 200. It's at the bottom of 200. It's only added if the defendant testifies. It's bottom of page 25. No, wait, hold it.
Yeah.
Sorry. Page. Wait, I jumped ahead. I apologize. I went over 200. That 200 is the, I was looking at by accident 300. 200 is the expert testimony. Was there conflicting testimony? All that much?
I don't know that it was conflicting, but the jury, I suspect there may be an argument that it was conflicting because of the sequencing of the significance of the toxicology versus the injuries, maybe. I don't know. If Attorney Zachar wants the resolving conflicts of opinion testimony, I'm not going to.
I don't know that there really was a conflict. I think Dr. Quinton and Dr. Christensen largely agreed with each other.
Yeah, maybe more of a weight question. So I'm going to take that out. I'm going to take that whole paragraph out. Sorry about that. Now we're at 300. 300 is not, that's what I was talking about, the defendant's testimony, paragraph about the defendant.
I usually ask for that to be included.
That'll be included.
No objection to the rest of 300.
Yeah, it's pretty standard. Any objection from the state? Um, 325.
Proper, Your Honor.
I'm just going to put in some of the witnesses. I don't think there was any delinquencies, right? I don't believe so.
It has the language there reflect convicted of a crime.
So wait, evidence has been received that some of the witnesses in this trial have been convicted of a crime?
The second one, I think we
Yeah,
were
we're talking about 327.
just one crime.
Oh, okay. I was about to say, you guys jumped ahead on me. All right, then we get to 340. Okay, 160.
Objection.
465, standard. 484 has not been modified yet. I know that Christina was working on it, so we'll have to modify that to reflect the language we have above. And then
I'll make the same request I make in every trial, Judge, and that be that consistent with the presumption that it's not offered as the first option.
yeah, I follow usually the general jury instructions. Plus, what's confusing in this case is because of how you have the lesser included, it gets even more confusing. So I think it makes sense. I'm going to leave it as is. And then that just leaves 115, which is a standard jury instruction.
515?
Or, excuse me, yeah, 515. All right, so we'll have to modify those. Work on the other acts for Mr. Pedrin. I think, as I said, we're also going to be working on changing 484, so it's consistent with the verdicts. Partially, the verdicts are being written, so I think that, yeah, I don't think she's got them done yet, but she's going to work on the verdicts and then change that. Anything else we need to do tonight?
I think there was a stipulation with Dr. Amundsen's testimony as well. I can draft, or we can draft something relative to that, just so it's part of the record.
Okay.
About the number of medical records reviewed?
Yes.
Oh, yes, that's what it was.
Number of pages.
That it was only 4 pages, not 1 to 200. Okay, yeah. Did you want me to read that to the jury at some point? I probably need to. Didn't I say it on the record? Yeah.
Oh, yeah, I mean,
Yeah,
if it's been instructed, I guess, like,
yeah, it was.
I mean, I would agree, we stipulated that, so.
Yeah,
So you know if you wanted a written stipulation that we all agree to that fact for the record.
that would be good, yes. It's already been said in the record, but that's fine. Okay. Listen, you guys had a long day, could have been longer. I appreciate the fact that we're here at 5 and not continuing much of the trial any farther. Anything further from the state? Anything further, Mr. Zachar?
Judge, just so I understand the court's timing here, if we're able to swing it, we're gonna go in, after rebuttal, we'll go into instructions and then closing arguments?
That's correct.
Perfect, thanks.
That's my goal.
Alrighty.
All right. Wait, hold it. You sure you don't need to say where things are in bags or anything like that? Just kidding.